Hello everyone, my name is Asako Ujima, and I am the current Title IX legal intern at TESA in Colorado Springs. As the title of this video indicates, we will be talking about the new Title IX regulations. We will also be covering strategies on how to mitigate changes that may disadvantage students that file complaints under the new Title IX rules. But first, we need to go over a quick disclaimer. The following video does not constitute legal advice and does not form a legal relationship between the viewer and TESA's Legal Services Department. If you need help regarding a Title IX matter, please contact an attorney. Alright, let's begin. On August 14, 2020, the new Title IX regulations took full effect. But the new regulations only apply to misconduct that occurred after August 14, 2020. Misconduct that occurred before August 14, 2020 will still fall under the previous Title IX regulations. But first, what is Title IX? Title IX is a federal law that prohibits sex discrimination in educational institutions that receive federal funding, which includes the vast majority of schools. Title IX covers all students, including those in K-12 in higher educational institutions, regardless of gender identity, and also covers conduct such as sexual harassment, sexual assault, and sexual violence. Let's go over some key terms that we will be using throughout this video. We will be referring to the individual who files the complaint as the complainant. And we will be referring to the individual who has a complaint filed against them as the respondent. The respondent could be another student, a teacher, or an employee at the school. The person who helps the complainant and respondent through the Title IX process is called the advisor. Anyone can serve as your advisor. They could be an attorney, a parent, a teacher, a friend, or a fraternity brother or sorority sister. In this video, we will first talk about changes to Title IX scope, procedures, and supportive measures. Then, we will go over some strategies to help mitigate potentially harmful consequences of the new regulations. First, let's talk about changes to the scope of Title IX. The new regulations significantly narrows the scope of Title IX. As a result, fewer complaints will make it to the investigation and hearing stages. The previous regulations covered all complaints of unwelcome sexual conduct, but the new regulations only cover conduct that falls under one of three narrower definitions. The first definition is any instance of quid pro quo harassment by a school's employee. Quid pro quo is Latin for this, for that. So quid pro quo harassment refers to a situation where a school employee makes a victim accept their sexual advances by offering them a benefit. An example of this type of conduct would be if your teacher offers you a good grade in their class if you have sex with them. The second definition is any unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it denies a person equal access to education. The misconduct would have to be particularly heinous in order to meet this definition. An example of a situation that would meet this definition is if a student in your class touches you inappropriately, calls you demeaning sexually charged names, and harasses you at school and online, and that happens multiple times a day, every day, for months. An example of a situation that wouldn't fall under this definition is if a student in your class calls you slut one time after class. That conduct is not acceptable, but unfortunately it will not meet the second definition. The third definition includes definitions that are borrowed from other federal law. Title IX borrows the definition of sexual assault from the Clery Act, and borrows the definitions of dating violence, domestic violence, and stalking from the Violence Against Women's Act, which is usually referred to as VAWA. If your complaint fails to meet any of the three definitions, the school can dismiss the complaint outright, without even an investigation. The previous regulations covered student misconduct regardless of where the misconduct took place. But the new regulations only cover student conduct that occurs on campus and on school-regulated or recognized activities and places. In other words, the new regulations no longer cover abuse that occurs off campus, outside of the United States, and online. Under previous regulations, schools that discover sexual harassment could launch an investigation if a responsible employee knew or should have known about the incident, even if the victim does not file a formal complaint. But under the new regulations, schools cannot launch a Title IX investigation unless the student, or parent if applicable, makes a report to the Title IX coordinator or official with quote-unquote authority to institute corrective measures. It may not be enough to report the incident to only the coach, residential life staff, or athletic directors. You must report the incident to the Title IX coordinator. Under the previous regulations, schools had to continue their investigation even if the respondent leaves the school or graduates. But under the new regulations, schools may dismiss complaints against students that leave or graduate and school employees who no longer work there. Under the previous regulations, former students, such as those who have transferred out, withdrawn, or graduated, could file complaints under Title IX. But under the new regulations, the student must be currently enrolled in the school in order to file a Title IX complaint. In other words, if the student leaves the school before a Title IX investigation is concluded, the school must dismiss the complaint. We've covered a lot, so let's review. This green square covers the scope of the previous Title IX regulations. The previous Title IX regulations covered all unwelcome sexual conduct. Under the new Title IX regulations, you'll first have to ask yourself, does my complaint fall under one of the three definitions? If the answer is no, the school may be able to dismiss the complaint without even launching an investigation. If your answer was yes, you'll have to next ask yourself, did the incident occur on campus or at a school-regulated or recognized activity or place? If the answer is no, the school may be able to dismiss the complaint. If your answer is yes, you'll next have to ask yourself, did you report the incident to the Title IX coordinator? If you didn't, the school will not be able to launch an investigation. If you did report to the right person, the next question you will have to ask yourself is the respondent still a student or employee at the school? If the answer is no, the school can dismiss the complaint. And lastly, are you, the complainant, still a student at the school? If you are not, the school must dismiss the complaint. But if you've answered yes to every single one of these questions, then you've made it to the investigation stage. The next category of changes we will cover are changes to Title IX's procedures. Under the previous Title IX regulations, live hearings and cross-examination were not allowed. But under the new Title IX regulations, live hearings are now required and cross-examination is allowed. What are live hearings? Live means that both you, the complainant, and the respondent will have to be present at the same hearing. What is cross-examination? Cross-examination is when the representative of the opposing side gets to ask you questions at the hearing. In the Title IX context, it means that the respondent's advisor will have the opportunity to directly ask you questions at the hearing. But the vice versa is also possible. Your advisor will be able to ask the respondent questions at the hearing as well. Under the previous regulations, students could fire an advisor and either proceed on their own or hire a different advisor. But under the new regulations, schools must provide advisors to students who do not have one, and once an advisor begins representing the student, they must continue to the conclusion of the misconduct case. Under the previous regulations, there was a 60-day investigation timeline that schools had to adhere to. But the new regulations are silent on any investigation deadlines. Further, if there is a related criminal case, a school can place a hold on investigating the Title IX claim until the criminal case is complete. That could take months or even years. The new regulations do contain one advantageous provision for the complainant. In the new regulations, your past sexual behavior cannot be used during the investigation unless it is used to show that someone other than the respondent committed the misconduct or to show consent. Lastly, let's talk about changes to Title IX supportive measures. Under the previous regulations, schools were required to take reasonable steps to ensure that the complainant is able to pursue their education without interference. This requirement applied to before, during, and after an investigation, as well as even if an investigation did not occur. But under the new regulations, schools may only provide supportive measures that are not seen as disciplinary, punitive, or unreasonably burdensome on the respondent. This means that the student who filed the complaint may have to put more of their own effort into changing their class schedules and other measures to avoid running into the respondent on campus. So what kind of supportive measures are available? Supportive measures include course-related adjustments such as permission to retake classes or exams, counseling, extension of deadlines, and transferring to different residential housing. It is important to note that you do not need to file a Title IX complaint in order to access supportive measures. Let's now talk about mitigation strategies. What if you're told that your complaint does not fall under Title IX scope? You should check your school's Code of Conduct or Student Handbook, because schools may still investigate incidents under their own Code of Conduct. Students and parents who find themselves excluded from the Title IX processes should pursue a claim under their school's Code of Conduct or Student Handbook. What if you're scared to go to the hearing because you don't want to see the respondent and don't want to be cross-examined by the respondent's advisor? The first tip is to try asking for an online hearing, so that you don't have to be in the same room as the respondent, but you'll still meet the requirement of a live hearing because you will both be present at the same hearing. If you can't get an online hearing, you can try asking that the respondent participate in the hearing from a different room. If they refuse to allow that, try taking measures to avoid contact between you and the respondent. For example, try staggering entrances and exits, assigning different parking lots, cafeterias, bathrooms, and hallways, and avoiding visual contact using screens. And lastly, if you know that the opposing side wants to conduct cross-examinations, you can ask to have their questions submitted to the panel beforehand so that you can better anticipate what they will ask. In conclusion, the Title IX process can be overwhelming and confusing. If you have any questions or concerns, please contact Daryl Glenn at the email shown here. Thank you.